not only be given testimony, but will be offering their thoughts and ideas about this. H.R. 2201 amends the Securities Act of 1933 to exempt certain micro offerings from the Act's registration requirements. Excuse me. Although small companies are at the forefront of technology, innovation, and job creation, they often face significant obstacles in obtaining funding in capital markets. This legislation will allow small businesses to operate with confidence that they are not violating the law when making a non-public securities offering. Simply put, it will allow small businesses the ability to access capital necessary for growth while reducing the disproportionate regulatory burden and legal risks that too often impede not only small businesses, but important job creators. Our federal security laws currently assume that all companies are similar and have the same ability, large or small, to hire lawyers, accountants, management consultants, and others to comply with complex security laws. This legislation will provide small business with a valuable tool to grow and unleash themselves within the free enterprise system. Without objection, I'd like to welcome the distinguished young chairman from the Financial Services Committee, the gentleman from Dallas, Texas, my dear friend Jeb Hensterling, as well as the gentlewoman, my dear friend from California, the ranking member, Maxine Waters, to our first panel. We're delighted to have both of you at the Rules Committee today to not only discuss this, but to hear your ideas as well about this important legislation. So without objection, anything you brought in writing will be available to our awesome stenographer. And I look forward to hearing from both of you. But before we do that, I want to defer to the gentleman, the ranking member of the Rules Committee.
Thank you, Mr. Chairman. I want to welcome our two witnesses, and let me just say in advance that I will be associating myself with the remarks of the ranking member on this bill. Our problem with this bill is that it would leave investors vulnerable to fraud by allowing companies to sell unregistered securities without important guardrails that normally apply to such transactions. And so I regret we're dealing with this bill, but I look forward to the testimony, and I yield back.
Thank you very much.
Chairman, I'd like
Yes, sir. Jim's recognized.
since we got y'all 3-2.
Well, is there a motion before the committee? But it's still very.
He'd hold it open for 6
Yeah.
hours.
Let me tell you, Mr. Chairman, I don't know whether you know this or not, but last week, the gentleman, Judge Hastings, celebrated his 25th year in Congress. And I went by to the party, was out front. Several people came and went, and I was out having so much fun with Stacy Plaskett that I missed Alcee. We were standing out front, and Stacy was telling me about her, really how things are going on the island, Judge. But I did not get a chance to express last week to you. Congratulations, not only for your service to your party and to your district, but to this panel here, the Rules Committee, and the Congress as a whole. And congratulations on something that few people ever achieve. Congratulations. Thank you, sir. Okay, we're going to get started here. Mr. Chairman, it's all yours.
Thank you, Mr. Chairman, Chairman Sessions, members of the Rules Committee. Thank you very much for the opportunity to testify before you on H.R. 2201, the Micro Offering Safe Harbor Act. I want to start by thanking the sponsor of the bill, Mr. Emmer of Minnesota, for his hard work on the legislation. Although small and emerging businesses are at the forefront of technological innovation and job creation, our government, through our one-size-fits-all securities laws, has imposed significant obstacles on their ability to get off the ground and grow. H.R. 2201 helps solve this problem by offering a common-sense clarification within the securities laws that will help ensure small businesses can efficiently and confidently access much-needed capital without fear of violating what is currently a very vague legal standard. Under the Securities Act of 1933, securities offerings, quote, not involving any public offering, unquote, are exempt from the Act's registration requirements. In theory, this means small and emerging companies can attempt to raise capital through non-public offerings, also known as private placements. without the burden of the significant cost associated with public offerings. And in theory, this makes good sense because non-public offerings generally are small in nature, in amount, and involve pre-existing relationships such as friends and family. But in practice, because the Securities Act does not define what constitutes a non-public offering, small and emerging companies can easily and unintentionally run afoul of the law if they do not engage very expensive lawyers, accountants, and sometimes even outside consultants to advise them when an offering crosses over from being non-public to public, again, a very gray area. The latter, of course, requiring registration with the SEC, very expensive registration. This bill will alleviate this confusion by amending the Securities Act to define the non-public offering exemption under the Act, thereby providing small and emerging businesses much-needed clarity and confidence from a compliance standpoint to better harness the capital formation tool. H.R. 2201 accomplishes this by creating one bright-line safe harbor for small private offerings, so long as each of three criteria commonly associated with non-public offerings are met. Number one, a substantive pre-existing relationship exists. Number two, the offering is limited to a relatively small pool of purchasers. And number three, the amount of the securities being offered is relatively small in size. In 2016, the Small Business and Entrepreneurship Council testified on this bill's predecessor and said, quote, entrepreneurs will be able to more easily launch their startups and existing businesses will have better prospects for growth. By simply clarifying an old law, more small businesses will raise capital through non-public offerings, easing the burdens of red tape, onerous paperwork, and threat of lawsuits, unquote. Mr. Chairman and members of the Rules Committee, nothing in this bill, let me repeat, nothing in this bill eliminates investor protections. Nothing in this bill lessens the SEC's authority to prosecute fraud or security violations. Any assertion to the contrary simply is not factual. Rather, this bill provides clarity to businesses and investors to know when a very small private offering is indeed a small private offering. And in doing so, this bill will allow more Americans to transform their ideas into small businesses, create jobs, and contribute to America's economic growth. I appreciate the opportunity to testify before you today, and I look forward to answering any questions you may have. And I yield back, Mr. Chairman.
Mr. Chairman, thank you very much. Ms. Waters, welcome. We're delighted that you're here. The gentleman will make sure that green light is on, and she may proceed.
Thank you very much, Mr. Chairman. Before I give my testimony, I'd like to say that I, too, attended the reception that was held for Mr. Hastings to celebrate his 25 years. He was not there. And the food was good. The refreshments were wonderful.
He left at about 2 in the morning.
Oh, no, Mr. Chairman.
Okay, maybe not.
Okay. However, thank you very much for inviting me. It was wonderful. Thank you, Mr. Chairman, Ranking Member Slaughter, and committee members for allowing me to testify today on H.R. 2201, the Micro Offering Safe Harbor Act. This bill is a misguided attempt to help small businesses that will instead harm investors, including faith communities. H.R. 2201 would create yet another loophole from the investor safeguards of our federal and state securities laws. Specifically, the bill would allow a company to raise up to $500,000 from 35 or fewer investors, subject only to the requirement that each investor have a substantive pre-existing relationship with the company. Unlike similar types of securities offerings, H.R. 2201 omits several critical investor protections that are characteristic of existing exemptions for small dollar offerings, such as disclosure requirements, limitations on advertising, and restrictions on resale. This bill also ties the hands of state securities regulators, raising the possibility that there will be no meaningful regulatory oversight of these small and local securities offerings. Importantly, H.R. 2201 creates a roadmap for affinity fraud. A bad actor, which would be permitted to use the exemption under the bill's current language, could easily raise money from close-knit groups at churches or community centers. In Los Angeles a few years ago, the SEC stopped an individual claiming to be a hedge fund manager who used his relationship with the Persian Jewish community to raise funds. The SEC's regional director stated that, quote, by exploiting investors' trust in him, the promoter was continually able to raise more money to pay back existing investors and finance an extravagant lifestyle, unquote. This bill would make it even easier for individuals to follow the same game plan. While $500,000 may not seem like a lot on Wall Street, for Americans on Main Street, losing even a fraction of that amount could mean the difference between retiring with dignity or not. Even Mr. Emmer's proposed manager's amendment, which seeks to add a provision to disqualify bad actors from utilizing H.R. 2201, fails to add legitimate investor protections. H.R. 2201 requires no disclosure to investors and imposes no obligation to notify regulators of the offering. This means that even if bad actors were prohibited, these convicted fraudsters and scofflaws would be left to police themselves. Additionally, the bill fails to take into account the numerous other exemptions we have for small dollar offerings, including under Regulation D, Regulation A, and crowdfunding rules. Given these existing exemptions, which provide ample opportunity for companies to raise capital while also protecting investors, I do not see the need for H.R. 2201. So for these reasons, I would urge my colleagues to join me in opposing H.R. 2201, and I yield back the balance of my time.
Thank you very much, Ms. Waters. Mr. Chairman, I come from Dallas, Texas, and a side of the community, which might be called East Dallas, where I served as chairman of the board of the chamber. And we had a cadre of young entrepreneurs, sometimes who had good ideas, sometimes who wanted to build on an idea, and sometimes had just a small business that wanted to get a little bit bigger. Is that what we're talking about here?
Well, absolutely, Mr. Chairman. And so, and yes, now I go to these very same East Dallas Chamber events, and it is a way for entrepreneurs to be able to raise capital. And again, one has to have a substantial relationship with the issuer of the security in order to be able to participate. And the challenge they have, Mr. Chairman, is according to the SEC itself, a registered offering is not economically feasible, quote unquote, for an issuer seeking to raise less than $1 million. So this particular safe harbor is limited to $500,000. And so this is just another avenue where the people you're familiar with can raise capital, incubate these ideas, and hopefully be able, the flip side of what the ranking member would say is that a lot of people may be able to participate. And who knows, perhaps even the next Apple or some other business that's born in a garage and ultimately becomes the next new great idea.
Well, I thank you for this, because there are lots of times where chambers of commerce, small business, people who maybe get their executive MBA, maybe an MBA, maybe a college degree, maybe simply a good idea from a trade school, actually want to get in the free enterprise system. There's a hurdle. There's a huge hurdle, and it's hard. And I did hear this often. I participated some myself with knowing people that wanted to take what they had and make it a better idea. I think this is a great idea, and it does matter. And the work that you do every day, seemingly, no matter how small it is, there's a marketplace out there. And I really appreciate you taking this. I look forward to telling my friends at the East Dallas Chamber how our young chairman of financial services heard them, took those ideas to work, and I know you speak to them every year and did something about it. I intend to tell the story, and I hope you will too, and I thank you very much.
Thank you, Mr. Chairman.
Mr. Chairman?
Well, I have lots of Hensling stories, many of which can't be told publicly.
Thank you, Congressman Cole. Let's keep it that way.
They all reflect well on you. It's only to protect my own reputation. But obviously I missed your testimony, although I'm familiar with the bill. And I don't want to go into that. I just want to tell my friend, you'll be up here, I know, a number of more times in the balance of time you have left. But as the chairman knows, Jeb and I were friends a long time before we were in Congress. And he ran the senatorial committee in the top staff part in 1992, and I ran the NRCC, and we became very good friends there. I will say one thing, I probably shouldn't, but it's a funny story. In 1992, my friend was running before me, and a mutual friend of ours was putting together a fundraiser for him up here. He contacted me. I said, well, of course, I'll participate in that fundraiser. I think it's a substantial six-figure participation, substantial for me. And so didn't think anything more about it, and all of a sudden my good friend J.C. Watts left, and I ended up running for his seat. Well, 2 days after my successful primary election, my phone rings from my friend. He said, I had no idea you were running for Congress. I said, I didn't either. I darn sure wouldn't have given you any money. I would have kept it for myself. And I said, well, I'll tell you what, if you're going to do any fundraisers in Dallas, and I said, well, I don't know. I said, I probably could do something around the OU Texas game. He said, you do a fundraiser in Dallas, and I'll bring a couple of my maxed out donors, and we'll see if we can help you out, which my friend did. But I've been very proud of Jeb ever since he's been in Congress. I think he's been really one of the brightest, most able, most principled legislators we've got. And, you know, people may have a different point of view on the other side of the aisle in terms of the philosophy, but I don't think they have any different point of view in terms of the character of the person, or the sincerity of the commitment. So, you know, the place gets diminished when good members leave it a little bit, and the American people always, matter of fact, send us other good people. So, but I will really miss you. I regret, I don't regret your decision. I respect your decision. You've given a lot to be here, I know, and still got a comparatively young family, and the lure of private life in this era is almost irresistible on some days. But you can be extraordinarily proud of the contribution you've made here to, certainly to our conference as a leader in that and as a chairman, but also I think to the Congress of the United States and to the quality of the national debate. You've taken on tough issues in a principled way and fought them through. And when there was a deal to cut or a deal to be had, you've known how to do that too. And that's a skill we don't see enough of around here. So I just want to tell you, I've enjoyed serving with you every day that we've had the opportunity to serve together. And just thank you for your service. Yield back.
Mr. Chairman, thank you very much. I want to join you also to let you know, Chairman Henserling, we had yesterday two gentlemen who were up here, Mr. Garamendi, Mr. Walden, who, like you and I, are Eagle Scouts. I want to throw back at you, thank you for your leadership, for scouting young men and young women and venturing who have taken time to commit themselves to a code of ethics and a code that was outside themselves but to other people. And I want to thank you for your commitment to that. I think that's
Chairman,
part
would
of
you
the
let me let
As
the record
Jeb Hensley
reflect,
does.
I was not an Eagle Scout, but I have one for a son. So, you know, there's you and my friend, the chairman, away from me by my son. But somehow I'm not surprised you were an Eagle Scout as well.
with honor and distinction.
Well, Mr. Chairman, if I could, I have recently had an epiphany, and that is no member of Congress is quite as popular as the day he announces his departure. But nonetheless, I am humbled by the kind words, but there's much work to be done in the roughly 1 year and 2 months that I will have the privilege, honor, and responsibility of chairing the House Financial Services Committee. So I look forward to continuing to work with all of my good friends and respected colleagues on both sides of the aisle, and look forward to many more appearances before this august body, the Rules Committee. But thank you for your kind words, Mr. Cole.
I believe you've done well enough to come back many times. Thank you very much. The gentleman from Massachusetts.
Thank you, Mr. Chairman, and I want to wish Mr. Henseling all the best. Although, as you point out, you're here for another year and 2 months, so that's a long time, you know. But I thank you both for being here. I think, you know, I mean, I've made my views on this bill clear. I want to commend the ranking member for her testimony, and I will yield back my time.
Thank you very much. Judge Hastings? Gentleman does not seek time. Thank you very much. The gentleman from Georgia.
Thank you, Mr. Chairman.
Yes, sir.
And Ms. Waters, if you're prepared to announce your retirement today, I will heap the same praises on you that have been heaped on.
No, sir, I'm prepared to announce that I want the position that he has.
I believe that's true. She's up for a promotion.
Good for you, good for you.
The truth is, Mr. Chairman, I needed this hearing today. The opening sentence from Ms. Waters' testimony was, this is a misguided attempt to help small businesses. Candidly, I appreciate it being recognized as an attempt to help small businesses, right? I mean, so often we disagree on what the goals are. In this bill, we're disagreeing about how to accomplish those goals, but agreeing on those goals. The concern that Ms. Waters expressed about investors being taken advantage of. I know my chairman shares that concern, believes this bill errs on the side of addressing that. The ranking member does not. I'm a little worn out on challenging one another's motives. I'm glad to be in a place where we're just challenging others' conclusions. And I feel like that's exactly the kind of job that we signed up to do around here. So thank you both for bringing this. I'm sorry we couldn't have a longer hearing that included flood insurance today, but I will look forward to that happening very, very soon as well. With that, I yield back, Mr. Chairman.
Thank you very much. Yes, I do anticipate we'll see you both back here at some point very soon.
Thank you.
Louise, thank you very much. How are you?
I'm sorry I missed it. You all look like you're having a good time up
We are. We were talking about how much fun.
there. Fun with the Rules Committee. I hate that.
Well, you know, a little bit of fun. We were talking about Judge Hastings having his 25th anniversary
Isn't that
party.
nice?
Oh, yeah. And he indicated that Maxine's in trouble by some of the things she said about how much fun he was having. So nothing but beatings around here. So, Judge, really congratulations. Mr. Polis, do you have any questions for our panel? No, thank you. Gentleman does not seek time. Thank you very much. Is there any member, the gentleman from Texas, Dr. Burgess?
Mr. Chairman, I'm not going to ask any further questions. I think it's been well explained by our two witnesses, but I'll just join in the accolades for my friend from Texas, and we'll have a few more times to observe your leadership. But it is we came in together, and it's been an incredible time. So thank you for your service.
Mr. Collins? Mr. Collins, Mr. Newhouse? No questions. Mr. Buck? Ms. Cheney? Mr. Chairman, we've got, and Maxine, we've got a great committee up here. We spend a lot of time up here with each other, but the times that we have are highlighted by your careers of others who come to speak and do legislation one way or another. And I hope that both of you recognize that part of your career has been to come up and fight for things which you believe in. And I appreciate you both very, very much, not only for your devotion to that duty, but really to the Congress of the United States. I'll remind you, we have an awesome stenographer here, and anything you brought in writing, she would love to be able to get from you to complete the record that is required from the testimony today. Thank you very much. Okay, is there any other member that would wish to be heard on H.R. 2201, Micro Offering Safe Harbor Act? Seeing none, this now closes the hearing portion of H.R. 2201. The chair will be in receipt of a motion from the distinguished gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 2201, the Micro Offering Safe Harbor Act, a structured rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule makes an order only the amendment printed in the Rules Committee report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in the report. Finally, the rule provides one motion to recommit with or without instructions.
Mr. Chairman, thank you very much. You now heard the motion from the gentleman from Oklahoma. One rule, one bill, and structured rule, 1 hour debate, makes an order, one amendment, and a motion to recommit. Is there amendment or discussion to this? No amendments. Thank you very much. All right, the motion that from the gentleman from Oklahoma. Those in favor signify by saying aye. Aye. Those opposed, no. No. The ayes have it, the ayes have it.
We would like a roll.
Gentlewoman asked for a roll call vote. Clerk will poll the committee.
Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Byrne, aye. Mr. Newhouse? Mr. Newhouse, aye. Mr. Buck? Mr. Buck, aye. Ms. Cheney? Ms. Cheney, aye. Ms. Slaughter? Ms. Slaughter, no. Mr. McGovern? Mr. McGovern, no. Mr. Hastings? Mr. Hastings, no. Mr. Polis? Mr. Polis, no. Mr. Chairman? Mr. Chairman, aye.
Clerk will report the total.
9 yeas, 4 nays.
The motion is agreed to. Accordingly, the gentleman from Windsor, Colorado, Mr. Ken Buck, will be handling this for Republicans.
And I shall handle it for the minority.
And Mrs. Slaughter will be handling this for the minority. Let's see, there's a question that's always asked, and the answer is, we do not currently expect any other meetings this week.
That's good.
Yeah. Thank you very much. This completes our work for the day. There's no complaint about